under the Constitution, the Federal Reserve shouldn't exist. And if we want to understand the constitutional arguments against it, we can trace its lineage back to Alexander Hamilton's First National Bank in 1791. And here from an article by Mike Meharry, he writes, after Congress passed a bill to establish the First National Bank in early 1791, President Washington asked Attorney General Edmund Randolph to prepare an opinion on the bill's constitutionality. Randolph, Mike writes, came down firmly against the measure, arguing that the Constitution didn't delegate to Congress the power to charter corporations. And Randolph, just like the arguments against the bank from both Thomas Jefferson and James Madison, which I covered previously in separate episodes, his argument was rooted in the 10th Amendment. And today I've got highlights on Edmund Randolph's take as well. But first of all, welcome and thank you for joining me here on the Path to Liberty. I'm Michael Bolden with the 10th Amendment Center, and this is the Fast Friday edition of the show for May 3rd, 2024. Now, Hamilton proposed the bank back in December of 1790. A month later, it passed the Senate, and a month later, it passed the House, so this moved pretty quickly. But during the debates in the House of Representatives, James Madison gave two major speeches on the national bank, opposing it primarily on grounds that it wasn't a power expressly delegated in the Constitution. He also rejected claims that used the general welfare and the necessary and proper clauses, of course, along with the power to borrow money and the preamble. That's from an overview that on the episode James Madison, the Constitution versus the National Bank, that I think would be really good for you to check out as well. It'll be linked to in the show notes at 10thamendmentcenter.com/path-to-liberty. But let's get to Edmund Randolph, the AG, who followed. So the first arguments were from Madison, and next up we have Edmund Randolph. And here from Meharry's article, he points out that as Washington considered whether or not to sign the bill, he discussed it with Randolph on at least two occasions between February 8th and the 11th in 1791. At Washington's request, Randolph provided a written opinion. And in a cover letter he sent with his draft dated February 12th, Randolph wrote that the substance of the dispute, well, it arises from an examination of the Constitution itself. Meharry said that in Randolph's view, the central constitutional question surrounding the bank was whether or not the federal government was delegated the power of incorporation. Like, is this a power that's clearly just spelled out? And he said it must be acknowledged that if any part of the bill does either encounter the Constitution or is not warranted by it, the clause of incorporation is the only one. But he points out that the power of creating corporations is not expressly given to Congress. And he said this is obvious. You could just read the text, and if it's not there, it has not been expressly delegated. So then if you want to address this, you have to think about other ways that it might be. And sometimes you play a little whack-a-mole with the opposition. But Mike points out that being the case, that it was not expressly delegated in the Constitution, there were only three ways the federal government could legitimately exercise the power to charter a corporation. And Randolph points out, we'll get to in a moment, that not just a corporation on a bank, but on any issue. So there's three things that Randolph addressed, and we're going to go through each of them briefly. First, because the nature of the federal government implies it. So just pure implied powers doctrine. Second, because it's involved in some of the specified powers of legislation. Or three, because it is necessary and proper to carry into execution some of the specified powers. And Mike points out that Edmund Randolph proceeded to dismantle all three of these arguments, just one after another. And he first starts out with implied powers. And Randolph put it this way: to be implied in the nature of the federal government would beget a doctrine so indefinite as to grasp every power. So in other words, as Mike puts it, basically, if you just claim that it's implied in the nature of the government, you're going to give them, in essence, unlimited power. So Randolph is saying this is not the case. And Mike writes, in other words, this implied power doctrine would give the government unlimited authority. But the Constitution clearly limits the scope of federal power. Whether you read it really broadly or not, you can read it as broadly as you like, but it certainly was not written with an intent of giving them unlimited power, even though people like Hamilton certainly wanted them to have that. Randolph then went on to point out, Mike writes, that the pending 10th Amendment, of course, we're talking about February of 1791, ratification of the Bill of Rights was in December of 1791. So this was already working. It had already worked its way through Congress. It was going through the states, and people were considering this, and it was very likely that it was going to get passed and ratified. Randolph went on to point out that the pending 10th Amendment made it clear that Congress possesses and claims, quote, no powers which are not delegated to it. He goes further. While on the one hand, it ought not to be denied that the federal government superintends the general welfare of the states, it ought not to be forgotten, said Randolph, on the other, that it superintends it according to the dictates of the Constitution. So here he is making very clear that, look, okay, you can say it's for the general welfare, but we have to think about that in regards to the powers that have been expressly delegated. And he goes further. So we're going to the next line. He moves to the second. Does the federal government have a delegated power that could be construed to authorize chartering corporations? So he says, we ask then in the second place, whether upon any principle of fair construction, the specified powers of legislation involve the power of granting charters of incorporation. So he's looking at primarily Article 1, Section 8 of the Constitution. He says, we say charters of incorporation without confining the question to the bank. Because if you say without it being expressly in there, that they have the power to charter a corporation to do this, this, or this, you're basically saying that they have the ability to create businesses or corporations in any realm. He says, without confining the question, I'll go back to that. We say charters of incorporation without confining the question to the bank because the admission of it in that instance is an admission of it in every other, in which Congress may think the use of it equally expedient. And Meharry describes it like this. Randolph noted that supporters of the bank bill justified this by arguing that a national bank would facilitate, and Mike puts that in bold text. He's really highlighting that they're arguing that it would facilitate the exercise of other specific delegated powers. The first was in the power to lay and collect taxes because, as Randolph says, they claim it facilitates the payment of them. Similarly, in the power to borrow money, it would be supported because a bank would create an ability to lend. So Randolph is kind of going through all the arguments of the supporters of the national bank, claiming under the Constitution that it facilitates one power, it gives an ability to help lend. Supporters of the bill, Mike writes, also argued that a national bank would support, quote, regulating commerce because, as Randolph notes, it increases, now this wasn't Randolph's position, he's arguing from their position, it increases the medium of circulation and thus encourages activity in industry. And finally, they asserted that it would facilitate disposing and regulating property because the contributions and the interests of the United States and the banks are the property of the United States. So over and over and over, they look at one power or another. It's not expressly delegated. So they're like, well, it would just help us exercise this power a little bit better or in various ways. But Randolph takes that to pieces. He says, in truth, the serious alarm is in the concentred force of these sentiments. So the view behind it, the underlying principle. If the laying and collecting of taxes brings with it everything which in the opinion of Congress may facilitate the payment of taxes, if to borrow money sets political speculation loose to conceive what may create an ability to lend, if to regulate commerce is to range in the boundless mazes of projects for the apparently best scheme to invite them from abroad, if to dispose of or to regulate property is to incorporate a bank, it may without exaggeration be affirmed that a similar construction on every specified federal power will stretch the arm of Congress into the whole circle of state legislation. So basically, as Meharry points out, Randolph was arguing that construing any of these powers in such a broad way would effectively annihilate the reserved powers of the people of the several states and create an all-encompassing federal authority. Mike says, in other words, the expansion of these four powers to justify a bank could be used to rationalize the expansion of every federal power to justify pretty much any federal action, leaving the states and the people no power at all. And of course, that brings us to the last argument that Randolph wants to hit on, the one that they all use, the necessary and proper clause. And like I mentioned in the other episodes as well, especially the one with Madison, when you find people who want to expand federal power, it really is a game of whack-a-mole. They'll start by saying, oh, well, this delegated power meant that. Oh, well, this is regulate commerce. Oh, no, this is promoting the general welfare. Oh, well, we think it's necessary and proper. And in another episode on the necessary and proper clause, I did point out that Edmund Randolph was actually one of the four very prominent lawyers who drafted the clause in Philadelphia. And while his view on necessary and proper really was not as narrow as either Thomas Jefferson or James Madison, he certainly rejected the Hamiltonian view of this on the other end of the spectrum. This will be linked to in the show notes as well. We all appreciate Alan Mosley for getting those organized. I'll get that published about a couple hours after the live stream is done here today over at 10thamendmentcenter.com/path to liberty. But here, Mike Meharry gives a summary of Hamilton's take. Hamilton argued that necessary could or should be construed as convenient. We know that John Marshall, later on, a few years later, he basically took the Hamiltonian view and in some places word for word reiterated this in Supreme Court precedent, that necessary doesn't mean necessary. Necessary means convenient. And of course, as Thomas Jefferson warned us, if you use that type of a viewpoint, there isn't a single thing that people with power will be able, would have problems torturing into a convenience in one instance or another. So Hamilton argued that necessary should be construed as convenient, and in support of his bill, he wrote, "It is certain that neither the grammatical nor popular sense of the term requires a strict construction. According to both, necessary often means no more than needful, requisite, incidental, useful, or conducive to." He said it is a common mode of expression to say that it is necessary for a government or person to do this thing when nothing more is intended or understood than that the interests of the government or the person require or will be promoted by the doing of this or that thing. And he specifically says it just is convenient to the exercise of our power. But Randolph actually, of course, hammered against this. Despite his nuanced difference with Jefferson and Madison on the necessary and proper clause. And if you want to understand that, it's a really kind of a deep, wonky conversation. That'll be in that episode, Constitution 101, Necessary and Proper Clause, that you should check out some other time. Randolph insisted that supporters of the bank, quote, ought not to claim any advantage from this clause. So he's taking the position that even though he disagrees with this very strict, narrow view of Jefferson and Madison, he's basically saying, don't take advantage of this because you can't, because these other guys are also wrong, the Hamiltonians. And he warned that a broad construction of incidental powers, we're talking about the legal doctrine of principles and incidents here, which is also covered in that episode, it comes with great risk. He said, however, let it be propounded as an eternal question to those who build new powers on this clause, whether the latitude of construction which they arrogate will not terminate in an unlimited power in Congress. Again, he's warning that if they read this thing broadly, they're establishing a precedent for, in essence, unlimited power. And what did the revolutionaries, what did the founders try to get away from? What did they fight a long, bloody war to free themselves from? Well, the unlimited power of the Declaratory Act, which claimed power over the colonies in all cases whatsoever. Certainly we saw that in one of the grievances in the Declaration of Independence. John Hancock cited this. Thomas Paine, the Declaration and Resolves of the First Continental Congress, cited this as the first thing that they were actually concerned about. That was the subject of the controversy between the colonies and Great Britain. So Randolph sums it up like this. He said, in every aspect, therefore, under which the Attorney General can view the act, so far as it incorporates the bank, he is bound to declare his opinion to be against its constitutionality. Now, 3 days later, Thomas Jefferson also came down against the bank, and I don't know if I have the episode up here, but he primarily opposed it on 10th Amendment grounds. He addressed the necessary and proper clause as well, and I'll have that link to in the show notes once Alan Mosley gets that organized over at 10thamendmentcenter.com/path-to-liberty. So you got these three Virginians, Thomas Jefferson, James Madison, and Edmund Randolph, all opposing the bank on constitutional grounds. Washington still went with Hamilton, and we are paying the price for that today. Anyways, I really appreciate you being here. I hope you enjoyed this episode. I hope you learned something. That's more important than anything. And if you want to help us spread the word about these essential foundational constitutional principles, absolutely nothing helps us roll up our sleeves every single day and do this kind of work and reach and teach more and more people, more than the financial faith and support of our members. So if you got a couple of bucks of that dirty government fiat that they keep depreciating every single day, we will take it and use it to take a stand for the Constitution and liberty, whether the government likes it or not. They certainly do not. So a couple of dollars a month, $2 a month is where it starts. We also have annual, 5-year, and lifetime options. Again, that's 10thamendmentcenter.com/members. Again, I really appreciate you spending some of your time with me today. I hope you enjoyed the episode. Thank you for being here. I hope you have an awesome weekend, and I hope to see you next week here on the Path to Liberty.